Hey guys, welcome back to another episode of Work Comp Talk. I'm your host, Carmen, and joining me today, of course, managing attorney Bilal Kassem from Pacific Workers, the Lawyers for Injured Workers, which also happen to be our sponsors for our episodes and podcasts. There's a lot to discuss. There's a lot of activity happening on our social media accounts, YouTube, TikTok. If you have yet to subscribe to any of our social media platforms, please do so. You can find us on the podcast, Work Comp Talk, YouTube, or you can also find us under the sponsors, Pacific Workers. Both of them share a ton of information, tips, and just dive into conversations that are all related to workers' comp. Speaking about workers' comp, one of the main questions we constantly get is settlements. And I think we should get a lot of questions when it comes to settlements. Today's topic is frequently asked questions within settlements in the California workers' comp system. So this would be a great time for you to hit the subscribe button. Like, for real, the subscribe button. Yeah, okay. So we had a discussion with some of the attorneys at the law firm, and there's a lot of questions that get asked frequently. Not only do these questions get asked internally with the law firm, but they also get asked constantly when we dump content on social media that is relating to settlements. One of those questions is, how much am I going to get? The number one question everyone wants to know, of course. If I'm settling, how much?
Absolutely. So settlements in California are kind of, to some extent, a little bit formulaic. I think the prime component of settlements is permanent disability, which means whatever functional limitations you can't have fixed through medical care ultimately are valued, and then that value is set by statute in California. So the higher percentage in permanent disability you have, the higher your settlement's going to be.
Correct.
And so when you have someone who comes in at the beginning of a case and they ask you, how much am I going to get at the end of this? A lot of times we say, we don't know yet. We're not going to know until you've been deemed permanent stationary and you get a permanent disability rating.
So the idea is to get you as much medical treatment as possible to make you, this is going to sound horrible, and I promise it's not coming from a horrible place, but to fix you as much and as best as the doctor can, to then figure out what part of your body is not going to be deemed fixable, and then there's a rating involved in it.
Basically, yes. And, sometimes there's different ways of coming up with permanent disability ratings. Some person may have limited range of motion in their arm or their shoulder, and so that has a rating. Or maybe they have a certain condition like a total knee replacement that also has an associated rating. And so there's a variety of ways that you can rate permanent disability. They use what's called the AMA guides for rating impairment, and that's what the doctors go by in order to assess the permanent rating for whatever body parts part of the case.
This is really good that we're talking about it, because I think this is the number one question, obviously, but it's that question that a lot of people are going to be mad about because they can't get a clear answer right away. And the fact that you just said there has to be certain steps taken before you can kind of get a ballpark idea of what's happening is just a reality check of, if someone's telling you, oh yeah, you're going to settle for like $100,000 and from the get-go, hello, get yourself together and make sure that you're being real and you're being told, hey, we can't figure this out until later. Because if someone is telling you up front, like, what if someone goes to an attorney and like, oh yeah, I can easily get you $100,000 for that knee replacement? Like, that's a red flag.
Yeah, and look, I've done this enough, as have a lot of the lawyers in my office, where we have some ballpark reasonable estimate of what a certain type of case may be worth, but things can
shift.
Yeah, things can shift really quick. I had a client who had a failed back surgery, and
Ouch.
You would think, okay, well, they have a lumbar fusion, they're probably going to have some range of motion, or this is the rating that would go along with something like this. This is typically what we see as the future medical care after that type of surgery. And so, yeah, the case is maybe worth X, Y, and Z dollars. But this person had a failed surgery, and their condition was made far worse to the extent they needed a pain pump, and they're constantly on pain medication, and they can't even lift their daughter and stuff. And so, yeah, we may have had an idea of what that case was worth when it came in, but not after that surgery went south. And so, things can change rapidly throughout the case that affect the value.
You know, I'm glad you brought that up. There was recently something that came up to me as well through the chats, through the system, through the comments that we constantly get. And it was this person telling us that, hey, I threw out my knee, and because I was limping and using my other foot, the good foot, now my good foot is screwed. So now I'm off on 2 feet. And it's like both of my feet are bad because I've been trying to like walk on 1 foot. And it was just like, again, you saying shit shifts, it does, it happens. Like,
yeah. And in workers' comp, that's called a compensable consequence injury. And the longer people are out, trying to get by on injuries, if it's especially involving body parts like your upper extremities or your lower extremities, where it's, one affects the other and your overuse and such, that happens a lot.
Damn. Yeah, it does. All right, cool. Well, that settles that question, how much you're going to get. And the other one also has to do with amounts of money. Obviously, they all do. It's settlements. But another big one is, hey, if I get a lump sum, let's just say, I got settled for $200,000. Am I going to get taxed on this money? What does that look like for me?
So workers' comp is supposed to be a benefit that's not taxed in California. It's not actually income. It's considered a personal injury award, and so it is non-taxable both at the state and federal level. I'm not a CPA. I've never worked for the IRS, but that is how it is. It's also typically exempt from bankruptcy as well. There's a variety of reasons.
Bankrupt, that's not included.
No, yeah, you have to declare it. You can't hide it. But if you tell the bankruptcy trustee that, hey, I've got this work comp settlement, or it's coming and it's going to be X, Y, and Z dollars, it's usually excluded.
Interesting.
And the reason is, it really isn't designed as income. It's not some benefit you got. It's not something that you earned or worked for. It's designed to compensate you for medical issues. And the legislature deemed it reasonable that people shouldn't pay tax on money that should be allocated towards their injuries and medical care.
Yeah, that would be cutting you short on it, and that would suck, dude.
Yeah, between that, you pay attorney's fees, you pay tax, you pay Social Security, all this stuff, you'd end up with very, a small portion of what you actually got. So
that would suck.
When we talk about settlements, let's say you get $100,000 as a settlement, the attorney fee comes out, but then the remaining balance is all yours, and there's no other deductions for taxes.
I have a ton of more questions when it comes to taxes, and I think I should leave this for another conversation. So let's just move on. But the next question is, how come I don't get settlements, or I don't get money, and I don't see money for pain and suffering?
Yeah. So in 2013, the law changed, and you used to be able to plead sexual dysfunction, sleep disorders, and psychological issues secondary to having a physical injury. So you would say, I hurt my back, and now I am depressed, I can't sleep, and I can't have sex. And so I want to be able to plead these things as compensable consequence injuries to my original physical injury. Well, a lot of people were filing kind of, I don't want to say, bogus claims, but claims where it's like, you cut your finger, it's all healed, but now you're claiming you're depressed, and like people were really stretching that and using that as a tool to work up the value of the cases. And a lot of it was justified,
Yeah.
but some of it wasn't. And also there was some trading that was going on at the time and lobbying. And really at that same time, the permanent disability rates were increased. And so there was a bit of a trade-off where on the applicant side of the bar, they gave up the ability to file those types of claims for permanent disability purposes. And so there are exceptions to that. If your injury is caused by a violent act or it's catastrophic, you are allowed to collect, pain and suffering, but it's in the form of psychological harm, meaning permanent disability and your future medical care for that component of the case. But it's much more limited than it was before.
Interesting. Okay, well, that answers that question. Okay, so this one's very interesting. Because they denied my treatment, why can't they be penalized for my damages for paying for those? So that needs to be a little bit more elaborate because it's even confusing to me. So they denied someone's treatment, right? And then you're settling, and you can't settle for any penalized stuff or damages because they didn't pay you for the treatment. Can you elaborate that question a bit better for me?
So I think the question's referring to the fact that in workers' comp, we have what's called utilization review. And utilization review is the insurance company's ability to review the treating physician's requests for authorization and say yes or no. Your doctor may say, hey, Carmen, you need shoulder surgery. You have a torn rotator cuff. It's the only way to fix it. The insurance company has doctors that look at it and say, hey, you didn't even have an MRI yet, or, you haven't tried injections, you haven't tried physical therapy. The doctor requesting authorization for surgery is too much too soon. We're going to deny it because it doesn't follow the treatment guidelines that the doctor's supposed to. And so at that point, the doctor's not allowed to do surgery for you. I mean, they can, but they're not going to get paid for it, which in practice means you're not getting it.
Yeah.
So there's that process of utilization review that either authorizes or denies requests. And so I think what that's referring to is the fact that some people need the treatment, and the insurance company is denying it because of either a legitimate rule or guideline, or they're not, and they're playing games. And that may cause harm to the person. Yeah. Maybe they needed surgery, 3 months earlier than they actually got it. And you see this happen a lot. There's an injury where people have a torn pectoral muscle, and it'll actually retract unless you get to it quick enough.
Yep.
Too bad, so sad, it's gone. Well, if you're sitting there waiting for, utilization review to approve it, and if that doesn't work, your IMR denial or your IMR appeal, you could be waiting 2-3 months before you even get to it, assuming you're successful. And so I think a lot of people have secondary injuries or complications because they didn't get the care they need fast enough. And that's a byproduct of the denials process or the reviewing physician's decision at utilization review. And so the question is, can't I sue for that?
Can I sue the insurance company for additional benefits for their negligence and stupidity of taking forever to answer my stuff?
And the answer is generally no. I mean, there are ways to recoup penalties and sanctions.
Okay.
So, there's a statute provided that you can actually succeed and you'd be able to recoup some monetary compensation for that within the workers' comp realm. But generally, you're not going to be able to go out and file, a civil lawsuit against the insurance company because of a legitimate denial of medical care that's by the rules that resulted in you having your condition be worse off than it would be otherwise.
So it's part of the process, unfortunately.
It's a really crappy process.
That's a sad one to talk about. All right. So do I need to stay within my work restrictions after I settle? Let's just say I'm done with my workers' comp. Of course, there were some work restrictions. Do I have to tell my new employer I got this new job? I'm not even trying to tell them I'm not supposed to do this. What are my options for work restrictions after I settle?
So when you settle a case, your doctor gives you permanent work restrictions. Well, once you're permanent and stationary. And those are designed to help you operate in a capacity that's not really going to cause further injury, right? So your doctor is going to say, hey, you know what, your knee's, this close to being blown out, you probably don't want to be squatting and bending and stooping a lot, and lifting a lot of weight. So I'm going to say, hey, you're going to have a limitation on how much you should be standing, jumping, whatever, right? Same thing for your back or your shoulder, lifting requirements, those sorts of things. And those are designed to protect you. They're prophylactic in the sense that maybe you could do those things, but they're either going to hurt or at some point it's just going to make things worse.
There's a consequence to it.
Yeah. So what'll happen is you'll get those work restrictions. You're supposed to stay within those work restrictions according to the doctor, but there's no rule, there's no law out there that says that you actually have to report those work restrictions to a new employer. You can choose to not abide by those work restrictions, but you're doing so at your own risk. But I know there's a lot of people that are in high-risk industries like construction or law enforcement, firefighters, whatever the case may be, where there's a good chance that they may get injured again. And
healthcare workers.
Healthcare workers as well. And there is a reputation to being someone who's got injuries and limitations, right? People discriminate against people who are in that position. And whether or not they say it, whether or not it's on paper, it's the reality for a lot of people. And that's why we have, anti-discrimination laws under California's Fair Employment Housing Act and, the Americans with Disabilities Act, which is federal law. But you're not allowed to discriminate against someone based on their need for accommodations or work restrictions. But people know that employers can still be super evil, and they'll be tricky, and they'll find some other reason to deny employment or pass over for promotion or otherwise. And so I get it. You don't want to disclose necessarily that you have work restrictions. And again, you're not going to get in trouble for it. It's not illegal. At the same time, you can't turn around, 6 months later and say, oh, well, I had work restrictions and, the new job is making me worse. And I told them I had work restrictions and, I want to sue them now. So you could still file a new workers' comp case.
It's a new workers' comp
But you
case.
wouldn't be able to, sue them for disability discrimination or anything. But I think the practical reality for a lot of people with, defined skill sets who've been in a career a long time and that's their only way of making money may sometimes choose to not follow work restrictions if they go to a new employer or disclose them because they're afraid of the repercussions.
Right.
So
I mean, I don't blame them. So yeah. I think the best thing here is it's at your own discretion, but know that you're also putting yourself at risk. Is it really worth it for you to blow out that knee and then be in some serious shit and then not have the ability to bend at all forever for the rest of your entire life? Those are some thoughts. Food for thought right there for sure. Okay, so this is another funny one. Why is my settlement so slow? We already talked about it and there was an agreement, but it's taking forever. My case took forever and I'm still in pain.
Yeah, so workers' comp takes a long time.
It does.
Workers' comp takes a long time. Well, in civil court, for example, we had a system called Fast Track. And when you file a civil lawsuit, you have a first case management conference. And generally speaking, at that first case management conference, the judge wants to assign dates for things like the mandatory settlement conference as well as the trial. And so when you're in civil court, you're kind of working in reverse. You're constantly asking for continuances and explaining why you're not ready for trial yet.
Right.
And there's an expectation that I think the goal for Fast Track is that 75% of all civil cases are tried within 18 months. And we don't have that in workers' comp. It's kind of just go as you need to. And a lot of these cases, there's a lot of stuff to work on, and it takes time. And oftentimes the process is slow. If I request a hearing on an issue that I want set for trial, I have to file for a mandatory settlement conference. That takes 45 days maybe to get on to the court's calendar, sometimes longer. Then at the mandatory settlement conference, assuming I actually get to set the case for trial, I get a trial date that sometimes can be, several weeks or, 2 months out. And then after that, I have to wait for the judge's decision. So even if it's a limited issue and it's pretty clean, depending on the court's calendar and the judge's caseload, it could take me 5-6 months to get a decision on something. And that could be a major issue for my client. Maybe it's benefits, maybe it's medical care authorization. And so the process itself for court, the process to get to doctors called QMEs for evaluations, that can take months on end. So a lot of this stuff moves in slow motion, and there's limited tools, I think, that the injured worker has by themselves certainly or represented that makes it even worse for them. But I think it's just the universe that we have to work in that makes it difficult to get things done expeditiously.
That just plain sucks, unfortunately. One of the last ones, which is another benefit that people are entitled to and sometimes are not even aware that they're entitled to, is the voucher. A lot of people, when they settle their case, then they get the voucher and they're like, what's this? Mm-hmm. So let's talk a little bit more about the voucher. We do have other videos where we talk about the voucher.
Yeah, the voucher it refers to what's called a supplemental job displacement benefit. And the idea is that if you have permanent work restrictions and your employer cannot accommodate those work restrictions, meaning they lay you off, then you should have some benefit provided to you to help you rehabilitate or re-educate yourself into the workforce. And so the voucher is up to $6,000 in reimbursement for job retraining or education and associated costs like a laptop and things like that. And so if you're losing your job because of those permanent work restrictions, the insurance company is obligated to provide that to you. And that comes if they cannot make a permanent offer of modified work within 60 days of you being deemed permanent and stationary. And so that voucher, it's not a cash payment. You can't go and spend it in Vegas playing roulette or whatever.
Damn.
It has to be used for coursework. And even within the $6,000 reimbursement, there's certain things that you can and can't use it for. You can only use up to 1,000 of it for a laptop, for example. The added benefit to that, though, is that if you're entitled to the voucher and your injury is after January 1st, 2013, which 2023, we're pretty far away. That's pretty much most cases these days. You're also you can apply for something from the state called the Return to Work Supplement. And California basically is acknowledging that, hey, $6,000 isn't that great for losing your job. Maybe you should have some more benefits. And that is a $5,000 supplemental payment that you get from the state. That is just a check. There's no conditions attached to it, designed, again, to help you get back on your feet if you've lost your job.
Interesting.
Mm-hmm.
Well, that's a lot to wrap up, a lot to discuss. We're going to dump a couple of videos that actually go into deeper discussions with certain one of these questions on the description below. Make sure you check those videos out as well. And most importantly, make sure you share this video. Check out the videos that we have on Pacific Workers as well, or vice versa. Check out the ones we have on WorkComp Talks pages. We thank you guys for chiming in, for giving us your 2 cents, your comments, for engaging with us on this platform, and we'll catch you guys on the next week. Thank you.